Assalamu alaikum, everyone. So in the criminal department, we represent individuals that were targeted by the FBI's counterterrorism unit and entrapped or were aggressively pursued for prosecution through discriminatory FBI practices. And largely, a lot of times, they were victims because of their vulnerable status. A lot of our clients are very, very young and were caught up in activities online. Oftentimes that started in video game chat rooms. We have a lot of clients that are recent reverts, so are easily approached and misguided, where informants approach them with information that's not correct about Islam. And we have clients that have been targeted by the FBI that are mentally ill, several of them that are mentally ill. We carefully select our cases that we represent at the center for the constitutional issues that they present. Our cases are typically federal criminal terrorism related offenses. And what I've learned in the 4 years that I've been here in this area of law is that it's extremely complex and very niche. Most criminal defense attorneys who get a terrorism related case will have never had one before. They're extremely unfamiliar with the unique laws and procedures that are involved in these cases, and they're not usually sure how to litigate them. And it's not just the criminal defense attorneys. The vast majority of federal judges around the country have also never had a terrorism case. There are a few districts that have had a lot. So for example, the Southern District of New York, the Eastern District of New York, Eastern District of Virginia, 1 or 2 districts in Texas. The rest of the country, it's completely brand new to most of these judges. And in almost all of our cases, it's the first time the judge is seeing one of these cases. So at the beginning, that's really bad for our clients because the judge sees this as one of the biggest, most serious cases they've ever had. We had a judge recently who kept referring to this case as like his Mexican mafia case, which told us a lot about the mindset he had about what he was dealing with. So in the beginning of our cases, most of our clients, which is not the norm, are detained. And that's because in terrorism cases, unlike all other federal cases, at the bond hearing, there's a presumption of detention for our clients, even though almost all of our clients are first-time offenders accused of nonviolent crimes. Even though they're terrorism related, there's no violence or harmful conduct involved. It's often about funding an organization or providing some sort of material support, oftentimes through the internet. But because of the way the law is in these cases, they're detained at the beginning, and so it's an uphill battle from the very beginning. We usually come into these cases as the experts, either assisting attorneys that have never dealt with this before, or we take over the case from other attorneys that are just ill-equipped to deal with it. But after that, this is where, us being the specialists have an advantage, because that's when we start educating the court. We litigate every single issue very heavily. Cases is brand new. So discovery is usually a pretty typical process. You criminal cases, very straightforward. What's Brady material? What's Giglio material? When it's produced? Not in our cases. There's classified information procedures. So all the evidence is classified. That means that there's a court security officer that is appointed to the case. A lot of times the judge has to review evidence to decide what can or can't be classified to the defense. A lot of evidence that you would typically get in a criminal case, so the informant's phone or being able to look into the informant's background and have their identity, they challenge all of that with us. And we've gotten really good at fighting back against that, and we file motion and motion and motion again to educate the court, that the rules of discovery aren't different in these cases, but it's an uphill battle. And through that process, we've uncovered a lot in these cases. I'll give you one example. In a recent case that we had a truly extraordinary outcome that settled on, we had pushed so hard on the classified evidence that it got to the point that they couldn't use their key witness because he was so badly compromised that all these things the judge, after we explained, had insisted they had to declassify all this information to us. They couldn't use him. And it would have, it would have slashed at least 2 of their very overblown charges. And that, resulted in a great outcome for our client. But this happens at all stages in our cases. One of the worst things we see in all of our cases is the extreme sentencing issues that our clients face. There is a sentencing enhancement called the terrorism enhancement that is exclusively applied to Muslim defendants. And it skyrockets the sentence. It makes the mandatory minimum sentence essentially about 18 years. And usually it recommends the highest sentence available. So that can be 20 years, 40 years, up to life, depending on the charge. And these are for often clients, this is a first-time offender, young, nonviolent. And we battle that in all our cases. We've heavily briefed this issue. We, write appellate briefs, amicus briefs around it all around the country. But there's so much more we can do, and we constantly have intakes on this. And I'm looking forward to engaging more with other Muslim attorneys around the country about these issues. But we really need your support to keep doing what we're doing in these cases. Thank you.